You guys might remember from earlier this year, there was a trial going on because Gretchen Whitmer was allegedly going to get kidnapped by some feds, and they managed to wrangle up a few hillbillies to charge with a kidnapping attempt, okay? They had this big fantastical claim, including some trap doors, and how a bunch of white supremacist hillbillies from out there in the sticks of Michigan were going to come and, I don't know, serve redneck justice against the good, precious Gretchen Whitmer. Whatever. That initial trial, it got thrown out mostly, okay? 6 of the defendants ended up getting acquitted. And the numbers aren't quite correct, but there were some acquittals. And then there were 2 mistrials without prejudice. So they ended up going back on trial. And now we've come to the conclusion of that trial, and boy howdy, is it corrupt as a motherfucker. Just gotta say that up front. Whitmer kidnapping conspirators found guilty. And how they came to that conclusion, oh boy, is certainly suspect. First and foremost, okay, the deliberations went into their 2nd day. I don't know how long the trial was. It's a federal proceeding, obviously, so you're not going to be getting anything firsthand because recording devices, and at least audio recording devices and cameras inside the courtroom don't exist. You get little snippets or secondhand reports from people inside the courtroom. The jury had found defendants Adam Fox and Barry Croft Jr. guilty of conspiring in 2020 to kidnap Michigan Governor Gretchen Whitmer, a Democrat. Oh my God, that'll give her the little bump in the polls that she so desperately needs. After about 9 hours of deliberation over 2 days, the jury convicted Fox and Croft of conspiracy to commit kidnapping and conspiracy to use a weapon of mass destruction. What? A weapon of mass destruction. Holy! Like, what kind of weapon are we talking here? The ones that Saddam Hussein didn't have? Maybe this little makeshift militia were the real terrorists when it comes down to it. Croft was also convicted of a possession of an unregistered destructive device. Oh, okay, cool. So it's less mass destruction-y. This was the pair's 2nd trial before U.S. District Judge Robert Jonker, fucking clown if we're being completely honest, okay? Because during just a couple of earlier this morning, I'll just go ahead and say that, okay? The judge refused to allow the jury to see a majority of the FBI entrapment text in Whitmer's case. Just keep that in mind, okay? Because we got some more details when it comes to this case and what the jury was instructed to pay attention to and not pay attention to, because it's fucking wild. First trial in April ended with the jury unable to arrive at a unanimous verdict. Oh, okay. Yeah, that's how the mistrial came about. Anyways, during the first trial, 2 other defendants were found not guilty. I got my numbers wrong, but I got things basically right. The 2 other men pleaded guilty and testified against Fox and Croft in both trials. Kind of like what's happening now with the Breonna Taylor thing. They flipped the woman. Imagine that. The woman squealed because I can't go to jail for 60% less of the time than any other man would get for the same crime. Anyways, in the 2nd trial, federal prosecutors relied heavily on the testimony of the 2 plea bargaining confessors, as well as the undercover feds who made this possible. Let's be completely fucking honest. The text messages, some of them, again, do we have to go back to what Jack tweeted out there? A majority of the entrapment texts in the Whitmer case were told were inadmissible by the judge. Fucking wild. And secretly recorded conversations to make their case. I don't know. Is Michigan a 2-party consent state when it comes to recording? It doesn't matter. It's the feds. They can do whatever the fuck they want. The defense unsuccessfully contended that Fox 39 and Croft 46 were lured into the scheme and were aided in making preparations by FBI agents and paid informants. Yeah, it was all set up by everybody else, and these 2 fucking retards were just like, oh, okay, cool. Defense attorneys tried to characterize their clients as inept, pot-smoking braggarts, and they were all talk and no action. Actually, yeah, no, and that would have been credible under any other circumstances, but I just want to take a look. Here's some of the jury instructions. We're going to get to, we're going to go back to the top of this, but this is what I want you to know. This is what the judge told the jury. It doesn't matter if the kidnapping was impossible to pull off. You still have to deliberate under the assumption that even if it was impossible to happen, they could still have been conspiring to do it. Oh my God. Like, if I was going to kidnap 3-legged aliens from the moon, okay? If I was going to hash out an entire plan, and one of them kind of looked a little bit like Ash from the Evil Dead with a Fran Drescher wig, I could still be held liable. That's fucking amazing. But let's get into how wild this trial apparently was. At the request of the defense, the judge on Friday instructed the jury in the Governor Gretchen Whitmer trial about what entrapment means. Through his instructions on what it doesn't mean may help the prosecution. At issue, did the defendants show any reluctance, the judge noted, or were they already willing participants? The crucial question in entrapment cases is whether the government persuaded a defendant who is not already willing to commit a crime to go ahead and commit it. U.S. District Judge Robert Jonker, I'll go with that one, told jurors who are set to begin deliberations next week of the retrial of Adam Fox and Barry Croft. Those guys right there, okay? Probably the two most familiar faces. At least these are the two folks that I associate most closely with the Wicked Witch of Michigan. Fox and Croft have long argued that they were set up by rogue undercover FBI agents and informants who they allege hatched a kidnapping plan and ran the whole show. Prosecutor says the defendants were armed, eager, and willing to kidnap the governor, but not the two other guys. Interesting. Never showed reluctance or discussed snatching a governor long before the FBI got involved. Yeah, no, exactly. They were willing to do it, except for they never, expressed any indication that they were wanting to do it, but they were willing to, I guess. In court Friday, Jonker, this is the judge after all, explained to the jury the following elements about entrapment. It's not entrapment if somebody is willing to commit the crime, which, okay, it seems like this set of facts and circumstances already, crosses that threshold. They were talking about it, but were they willing to act on it? No, not until the Fed showed up. Oh, okay, cool. Even if the government provides someone with a favorable opportunity to commit a crime, wow, okay. Even if the feds drive you right to the front door, give you a big old net, and just tell you, hey, she's inside, second floor, third bedroom on the right. It's not entrapment if the person is already willing to commit the crime. He sat in the back seat and he buckled up his seatbelt. So that, to me, is willingness to commit a crime. Okay. It's sometimes necessary for the government agent to pretend to be a criminal. Okay. Pretend to be a criminal. How much intervention did the feds have on this one, okay? Were they the ones who were just, using a little Lego man in their little theoretical scheme to plot everything out? And then those two dorks were just over there just smoking pot in the corner? Great. Did they show reluctance? And if they did, were they overcome by persuasion? If yes, how much persuasion did the government use? Again, text messages would be very, very important in this one, but they didn't get most of them. To prove entrapment, the defendants must show that the kidnapping idea and momentum of the crime was introduced by the FBI, and that they were not already willing or predisposed to commit a crime, a point Jonker stressed repeatedly. Jonker named two vital aspects of the entrapment defense. The government had to take an action to push the defendants to take actions towards the crime, and defendant had to be at least initially unwilling to commit the crime. And here's where it starts to get buck wild. The judge also had to tell him, don't be swayed by my actions. Listen, I know during the proceedings of this trial, it looked like I was favoring the prosecution, okay? And I was admonishing the defense because, well, we both have our paychecks signed by the same people, okay? Don't worry about any of that stuff, okay? It's fucking wild. Jonker's jury instructions touched on many themes and controversies that unfolded during the trial, including the defense accusing him of favoring the prosecution. Well, if the shoe fits. Jonker repeatedly interrupted the defense lawyers during the cross-examination of government witnesses. Cut short their questioning. Scolded them for what they viewed as redundant or irrelevant questioning. Did the prosecution lodge any objections, or was the judge just intervening? Okay, cool. The defense could only take as long with a witness as the prosecution did. Some courtrooms, that's what they allow, so that's a little bit fine, but if the prosecution continues to bring up police officer after police officer after police officer and ask them very short, very pre-planned questions in order to get stereotypical and rehearsed responses out of them, I could see a little bit of a problem here, but I don't know the witness list on any of this stuff. It could be a total setup, okay? That's the least charitable interpretation of these facts. At one point during the trial, with the jury present, the he told a defense lawyer, start focusing on what's important the issues are before the trial stretches into Thanksgiving. I've seen a fair few trials at this point, and sometimes you have some defense attorneys and even the prosecution not be able to stay on track and ask some very obtuse, very poor questions. But dude, you're just doing a retrial because, hey man, your team couldn't present a coherent case to begin with, so now you got a second kick at the cat, and you guys managed to win this time because you really tightened up the reins. Wild. During jury instructions, Junker urged the panel to decide on the case, only the facts, not on anything he said or did. Honestly, if he was continuously admonishing the defense, you're gonna have a warped perception of what they were presenting before you. Just saying, if the judge and the prosecution made the defense, or maybe the defense's actions made them look inept, the jury's not going to look on them too terribly favorably. Nothing I have done was meant to influence your decision about the facts in any way. Again, is a direct quote. Start focusing on what the important issues are. Okay, he was deciding what the important issues are. Just saying, okay? Junker stressing only witness testimony and exhibits approved by the court are to be considered. Oh, okay. Nothing else is evidence, not the lawyer's statements or arguments, nor my legal rulings. Yeah, that's pretty standard stuff. Please don't interpret my rulings as suggestions one way or another. Don't let them influence your decision. Don't pay attention to the man behind the curtain. Okay? And this one right here, I got to get to the bottom of this because this is fucking buck wild. Junker also explained to the jury the crime of conspiracy, which is what Fox and Croft Jr. are charged with, as kidnapping never actually occurred. Yeah, we don't even know how far they got along when it came to enacting this plan in any form or fashion, but apparently, even if it was impossible, don't worry, you guys were planning, and that's wrong. You stop it. The FBI arrested 5 men in a sting in the fall of 2020, alleging fears grew that the group was close to acquiring explosives to blow up a bridge to slow down cops during the kidnapping. Is that what Croft or, I don't know, Beardsley ended up getting charged with? Fox and 4 others were arrested in a sting outside a Ypsilanti warehouse. Croft was arrested at a gas station in New Jersey. Wow, that dude was getting the fuck out of there. Junker explained that to prove conspiracy, the government must show the following. 2 or more people agreed to commit a crime. A Fed and person that they're trying to convince and coerce. Okay, we got that. Even if they never actually achieved their goal. Yeah. You can have conspiracy to commit a murder, okay? If you go buy the gun, you set the plans, you write everything down like an asshole. That's conspiracy to commit murder. Conspiracy to commit a crime, follow it along, everything else. Okay, everything checks out so far. 2 or more people agreed to commit a crime. They also must have knowingly and voluntarily joined the plan, and that a conspirator did 1 or more overt acts to advance the plan. Okay, that all makes sense. That all makes sense so far. It doesn't have to be a formal agreement, Junker said, nor does everyone have to agree to meet the legal standard for conspiracy. Wait, what? However, Junker said people simply meeting from time to time is not enough to establish a criminal agreement. That's kind of what we've seen here, because this was first labeled as a very high-tech militia. The Wolverine Militia was what I think they were called at the time, and realistically, it just kind of broke down to being kind of a drinking and a pot-smoking club that a bunch of guys out there in the sticks were, I don't know, meeting and congregating for a barbecue or to throw back a six-pack every once in a while. And it's like, oh, okay, cool. This is what the defense argued repeatedly at the trial. The defendants were merely a group of big-talking pot smokers who hung out at a campfire, drank beer, got high, and invented about the government. Yeah, it sounds like literally everybody in my community. That's why I hate camping, and it's fucking boring. The prosecution counters that they did a lot more than vent. They also took action, facilitated by the feds. They said, including... they cased the governor's house twice. Oh, okay, cool. Built shoot houses and practiced breaking and entering into make-believe rooms. Drew maps, okay. Bought night goggles and communicated in encrypted chats to hide from law enforcement. Oh, like what? WhatsApp? They use Telegram? Like, come on now. It's not as high-tech as you make it out to be. Junker said the government must show that there is a mutual understanding to cooperate with each other to commit to the crime of kidnapping. Cooperate with each other to commit the crime of kidnapping. Okay, form a plan. Okay, hash out all the details. Even if it's not possible to do, that's where the disconnect starts to come in on this one. During the trial, Yonker reminded the jury that it didn't matter whether the alleged kidnapping plan was a good plan or a bad plan. It sounds like it was kind of retarded, because she's going to have armed guards and armed security with her at all times, because this is Gretchen, everybody else stay in your house while me and my husband go on a yacht on Lake Michigan. Whitmer, so same bitch who said that don't worry about going outside to garden because there's still snow on the ground. So because there's snow on the ground, you guys, everybody has to stay inside at all times because of safety, right? The defense argued that any alleged kidnapping plans discussed by the defendants were high talk by men engaged in fantasy play, such as abandoning Whitmer in a boat on Lake Michigan or whisking her away in a helicopter. Did anybody purchase a helicopter? Did anybody rent a helicopter? And given the subject matter here, was Pinochet's helicopter available? The judge, however, told the jury on Friday, you may find them guilty even if it was impossible for them to successfully complete the crime. Wow. So I don't know. That doesn't sound good to me. That could be sound legal theory, but realistically, if that's one of the final things that you're going to hear from the judge when you head into deliberations, it doesn't matter if they could even accomplish their said goal, okay? You guys have just heard days and days of testimony from the government that these guys were planning to commit a crime against Whitmer, okay? It doesn't even matter, okay? Hey, man, if the defense even caved on one point, that was out there, okay? It was just a bunch of high talk by a bunch of men who were engaged in fantastical fantasy ideas. They were going to use Wonder Woman's lasso of truth in order to get the real ideas out of Whitmer, okay? And then throw them on the back of a unicorn or a Pegasus and then just fly across the Great Lakes, okay? Even if all of that's impossible, they still had a plan, and you need to find them guilty. What? That is wild. And if we are led to believe, at least by the word of Jack Posobiec, that text messages, very vital text messages, were being left out, and if that's the standard, and if that gets put into an appeal, it seems pretty strong. But we don't know how long these guys are going to be behind bars, potentially. Okay, we know that it carries up to a life sentence, and because it involves one of Biden's chosen women, yeah, it could be pretty steep, but I'll be waiting for an appeal on this one because it just looks pretty ripe for appeal, honestly. Considering the first trial, then the outcome of this one, yeah, I've got questions. More questions than we have answers. So with all that said, thank you all very much for the gift of your time. I've been Don Consuelo. I want you to follow your gut and get after it. Take care, everyone.